Okay, good morning, you lovely New Zealanders, not Aotearoa rights. We're all New Zealanders. We've got 160 cultures living in this country, and we should all be treated absolutely equally, with no special favours to any culture whatsoever. That is called democracy. Okay, what we're doing is we've been discussing Tikanga, which is Maori law, philosophies, religion, beliefs. It's really a set of religious beliefs, in my opinion. We've been going through a book, a chapter of a book by Adam Plover called The Benefits of Colonization, which I hope you all can get a copy of this and read it for yourself. But I'm going through a particular chapter 16 of this book, which is very good about Tikanga. Today I'm talking about the case in the High Court here of Edwards, which was a claims by tribes for large swathes of the foreshore and seabed. Now, we started talking about this yesterday, and of particular interest is Judge Peter Churchman, who ignored the clearly stated intention of the democratically elected Parliament of New Zealand by putting in non-law tikanga above the requirements in the Marine and Coastal Area Act S58. That the claimant must prove that its members have exclusively used and occupied their claimed area from 1840 to the present day. So if you want to get customary marine title, if you're a Maori tribe, you must prove that you've been using it since 1840 exclusively, and you must prove that you've been using it between 1840 and the present day. Now watch what happened here with Churchman. This is Tikanga. Up until the assertion of sovereignty by Great Britain in 1840, the sole system of law in New Zealand was Tikanga Maori. He falsely asserted, that's Churchman, before waffling on about Earth Mother and Sky Father. Can you believe it? He said, with the earth being created when these two were thrust apart by their children, and other such juvenile Maori witch doctrine, which should have no place in a modern court of law. By basing his judgment on a fictional system of law that never existed, Churchman's whole rotten judgment seems to be based on a lie. Since the claimants could not succeed in accordance with the clearly stated words of the Act, in other words, the Maori tribes who were coming to the courts were saying, hey, we can't prove that we've been using it exclusively and continuously since 1840. So what did Churchman do? Well, that should have been the end of it, but instead Churchman said the task of the court in considering whether the requirements of S58(1)A of the Act have been met is therefore not to attempt to measure the factual situation against Western property rights, or even the tests of common law for the establishment of customary land rights. So what he's saying is, hey, you know what? We're not going to look at what Western property rights say. We're not going to go to standard law to judge this application for customary rights to a whole piece of the coastline. This is what he actually said. He said the critical focus must be on tikanga and the question of whether or not the specified area was held in accordance with tikanga that has been established. You know, you wouldn't make this up, but this is what he did. But it got worse. So he was overruling Parliament at this stage, because Parliament said they must be able to prove, anybody making an application must be able to prove that they have had exclusive use of the coastline and continuous use of the coastline since 1840. But then this is what he did. Churchman then passed on the whole thing to a couple of part Maori, Hiria Hape and Doug Haraki, who are not part of the justice system but who have spent their careers in advancing Maori culture and Maori interest as to whether these applicants who failed to succeed under the Act held their claim according to Tikanga. So what he did was, Churchman said he wanted advice from 2 Maori experts, these 2 guys here, Heria Hape and Doug Haraki, to tell him whether he should award this tribal group the coastline according to Tikanga. He really did this. Now, you know how, first of all, what's the judge doing relying on a third-party group like this to tell him how to do his job? And secondly, you know how Maori are related to each other. And, you know, if you ask a Maori to help sort out another Maori issue, it's highly likely you're going to get a great result because they're all in on it. It's an inside job. It's like asking the mongrel mob to investigate the mongrel mob. And of course, what happened was the claim was granted. These experts, so-called experts, this is what they do. This is how Maori radicals are getting away with a lot of things in New Zealand, is they're calling in experts. And these experts are no more than just ordinary people who've probably got a vested interest in the case. They're doing this with the Waitangi Tribunal. They're saying the only people that can tell you what the treaty means are experts inside the tribunal. The only people who can, say what's going to happen in Te Papa with what's going to be displayed in there are experts. So it all comes down to these experts in tikanga law. And of course, what this does is it opens up the whole legal system to massive corruption, insider jobs, insider trading. Because tikanga is an oral law, there's nothing written down. And you can make it up as you go along. No one group in New Zealand has any written tikanga. It varies from tribe to tribe, from hapu to hapu, from iwi to iwi. And so this is an absolutely mind-boggling, corrupt system that's about to be introduced into New Zealand. And we need to stop it.